But speaking of the more white pill SCOTUS moment is some
Please.
promise we got from a case we've talked about several times before, but now the Supreme Court has taken the case, which is the wealth tax, repatriation tax.
Oh, so okay, you might have to do this because I'm gonna have to open up the lawsuit again. This is where they wanted to tax a husband and wife on reinvesting their profits into the company on unrealized gain by saying you didn't realize your gain, but you had it and you're reinvesting it, but we want to tax you as though you had cashed it out, even though you reinvested it. Did I get it close enough? Because
the key is it goes back to the 16th Amendment. And the reason what's lurking in the background of this case, this is the mandatory repatriation tax pushed by Paul Ryan that, quite frankly, that Trump signed, and that this aspect he shouldn't have signed. And it should tell you a lot about who Paul Ryan really is. Buried in this law that was supposedly about cutting taxes, supposedly about standardizing global taxes of corporations, that had a lot of good things in it. But as always with the Paul Ryans of the world, buried in it was one of the most dangerous tax laws ever passed. And it was disguised as a mandatory repatriation tax. But really what it was is Congress are trying to assert their authority to impose a property tax, a national federal property tax, which Elizabeth Warren likes to relabel a wealth tax. But if you think it's going to start with a wealth tax, I remind you of what a congressman said in 1916 when they passed the Revenue Act of 1916. He goes, this tax, and when they passed the 16th Amendment before that, 1913, said this tax will not tax a hair on a working man's head. Well, you can see what it's done to my working man's head. That's how that tax is for. So the nature of this is buried in the mandatory repatriation tax is a right to tax you on your property as earnings. And in this case, the tax allowed a tax even without you making anything. It was simply, did you have stock in a foreign company during this time frame? We are going to treat it as if you had a distribution, even if you didn't have a distribution, even if you couldn't have requested a distribution, even if you had no control over it. So it's unretained, unreceived earnings. Are being treated simply for appreciation of the value of the stock. So the problem with this, of course, is this would allow a stock tax. This would allow a house property tax. This would allow a car property tax. You name it. A national federal property tax.
And I made the same joke the last time. They'll tax you on the unrealized gains, but you will not get a deduction for the unrealized losses. Bullshit.
That's absolutely the case under this provision. You don't get the losses. So the problem with that is our Constitution, back at the time they were designing it, the anti-federalist types, even within the Constitutional Convention, were deeply concerned. The Articles of Confederation didn't give any federal government taxing enforcement power for a reason. Didn't trust it. They just gone through a revolution to stop a centralized government from being able to tax them directly. And the most hated tax is what's called a head tax, a tax just for existing, right? Goes all the way back in Old English history and before in almost every society and civilization. And people didn't want tax on their property either, just for owning a farm or anything else. And so the law was there'll be no direct tax without apportionment. And the goal was apportionment required the state. It made so that one state couldn't say, well, we're going to screw you. We're just going to tax the people in that state. And that was part of what was behind all of this. Was this apportionment requirement is almost impossible in the modern age, and it was even then, to actually enforce, to actually do. You couldn't do a tax that honored apportionment without political massive backlash and procedural, administrative, bureaucratic enforcement nightmares. So now throughout history, they have occasionally avoided this. There was a carriage tax that a bunch of justices said were okay, that somehow they claimed it wasn't a direct tax. That was garbage. But for the most part, the federal government relied on external taxes, excise taxes, tariffs, etc., for their control over the borders, where they did have taxing authority. During the Civil War, Lincoln used it as a pretext to put in an income tax before it could ever be fully struck down. They got rid of it in 1865, 1866. And then they brought it back in the early 1890s. Went up to the U.S. Supreme Court. Supreme Court said, no, you can't do this. One justice dissented. The justice who dissented in Bushaber said, no, the income tax could be constitutional if you were only taxing gain severed from the source. Now, what that always meant was unclear, but it means you only taxed when you actually receive a gain. Then you weren't taxing property, you weren't taxing labor, you were taxing a gain you received from it at the point of distribution. So then, but that was the dissenting judge. The 16th Amendment comes in. It says Congress doesn't have to worry about apportionment when it's taxing income. Definition of income is not in the amendment. Goes back up to the U.S. Supreme Court. That dissenting judge is now chief judge. What do you think the chief judge says? The chief judge, in interpreting the Revenue Act of 1913, and it's, by the way, the reason why every Revenue Act since then every Revenue Act of 1916 forward says, in lieu of the Revenue Act of 1916, they never mention the Revenue Act of 1913. And the reason for that is what the Supreme Court did in 1916. Pollock was the original case. Bruchaber was the follow-up case. So the dissenting judge in Pollock, now the chief judge in Bruchaber, he says, you know what the word income means? It means what I said when I dissented back in the Pollock case. I was right all along. And so what income is gain severed from the source, and that's the constitutional definition of income, and it's the limited, constrained definition of income. Congress just can't label anything it wants income and thereby tax it. They have to accept my definition of income as being the 16th Amendment because of my dissenting decision back in the 1890s. That's why Congress ever since has begrudged that decision and has always wanted to expand its taxing power, so it decided to never define income ever again. Now, in the history of Anglo-American legal jurisprudence, that should mean every income tax is unconstitutional. But good luck finding a judge or an IRS auditor or politician who will go along with you, as the tax protester movement has found out, unfortunately, the hard way. They're not going to cut their paychecks anytime soon, and that's who do you think pays them? So consequently, they've avoided this legal limitation of their power. And they every now and then they try to get a little bit more, and they try to get a little bit more, and they try to get a little bit more. I mean, that's why the definition of income is actually circular and self-referential, as the Supreme Court recognized in an issue about a decade ago. Because the word gross, it's called gross income. And it's all from all income received. It's all income from income received. And you start to figure out, hold on a second, you still haven't defined income. And there's also a missing liability section. Who is it supposed to pay? That's because, again, they're trying to dodge what the limitations on their power are. And now the mandatory repatriation tax, they're going right for it. They're saying we have the right to tax unrealized earnings, unrealized gains, and just pretend they're gains. So we're not taxing property. We're just taxing the increase in the value of your property, which is otherwise known as taxing property. So that's why this case is as consequential to Congress's taxing power, and the power to tax is the power to destroy and is the ultimate state method of control, is probably, in my opinion, the most consequential case before the Supreme Court this term.
Was that the cert? That it was the petition for cert, so they're going to hear it now.
And the Supreme Court's already taken it, yeah.
Okay, good. And the decisions come down by
summer.
So June 2020.
It wouldn't surprise me if this one came down like February or March.